Happy Thanksgiving. Okay, and yes, I'm wearing a turkey on my head. It's like Galini family tradition, at least in my immediate Galini family, not my parents and siblings. We did not wear turkeys and other things on our heads. This is something my wife came up with, and we've been doing it for a while, and so I've been wearing it all day. All right. Okay. Now, this question, I answered a similar one the other day, but this is slightly different, so I'm going to go ahead and answer it. And has anyone filed due process complaint without an attorney? Okay, that would be pro se, is how you would say that if you were acting as your own attorney, which under special education law, you can do that. You're allowed to do that. It is sort of designed, Congress sort of designed this entire process for parents to be able to advocate for their child without the need of an attorney. Now, at the same time, is it a fair fight? No, it is not a fair fight because the school has their attorney paid for with your money. And this attorney cannot get involved in the early stages of your due process. But at the same time, don't be naive. They're in the background advising, consulting, and guiding the school system through those early stages. Now, if you end up going to an actual hearing, then yes, it will be the board attorney trained in this area and knowledgeable with an expertise likely in this area of all the nuances and understanding what you would need to show to the hearing officer in order to prevail. You would not have that benefit if you acted pro se or, as your own attorney. So what's the difference? Now, the track record for parents acting as their own attorneys nationwide is abysmal. Not good at all. And I think a lot of it is not necessarily the attorneys. But I think it has everything to do with a parent not understanding how to present the evidence. And, they tend to go in there and base the argument off of emotion and, off of how it's impacting your child and what I consider the feelings categories. And that's not law. All right. Law, you got to scrub the feelings. It's used as part of the acting job that lawyers are required to do during the presentation of the evidence. You always want to put some sizzle on the steak. Okay. So, yes, you need to infuse that, but you need to know when to do it. And then you need to make sure that you are clearly focused on what you need to show. And whatever your issues are, and you need to make, and the hearing officer will typically guide you along to sit there and try to clarify the issues that you're having. Now, is it a denial of a free and appropriate public education? And that's a fairly broad concept. So if it's a denial of a FAPE, then what you've got to focus on is the substance, not the procedure. All right. Not that they didn't have a meeting within 30 days. They had it in 35 days. Nobody's going to care. All right. 5 days didn't cause education damage to your child. And that's all the hearing officer is going to care about is how did these mistakes cause your child harm? Did your child stagnate with regards to their progress? Did your child regress? Those are going to be the two things attached to what a FAPE denial is. And that's what you would need to be focused on, and that's what your evidence would need to show, is that your child stagnated, has not made tangible progress, or your child has regressed. That would be the substance of your child's program, which we call substantive harm. Okay? Now, if there are procedural violations, they didn't cross the T's, dot the I's, they didn't follow procedure, some of them, if there's enough of them, can be to a point to where it can tip over and cause damage, substantive harm, or your child regressed or your child didn't make progress. So yes, procedural can, but you would need to have a lot of them, and you'd need to make sure that you explain them to the point where it's very clear to the hearing officer that your child was harmed substantively by the procedural violations. Now, if it's one of the other areas, eligibility, then obviously you'd need to have your evaluations. You would need to have your expert talking about the evaluations and what the evaluations show. You would need to know what your state minimum requirements for eligibility would be, so that you could sit there and, really show how the school was wrong. If it's a discipline issue, then you would need to sit there and show where the FBA wasn't done properly or not done at all, where the behavior plan was crappy, or they didn't have one. And you need to show a pattern of removals from the learning environment, and all of those things resulted in harm to your child substantively because they were not in the learning environment, they were not making progress, and a FAPE was not provided. So on the behavior front, manifestation, all of those things, you would have to point them back to how it created substantive harm for your child. And that's what you would need to focus on, not the emotion. And, you're going to have a lot more flexibility than, let's say, an attorney with regards to procedure. I'm talking about, the rules of civil procedure. As far as objection or leading witnesses, things of that nature, you're going to have a little bit more flexibility because you would not be a trained attorney. Even though the attorney would sit there and if try to throw you off your game by objecting every 5 seconds. So make sure that you would have your notes written out clearly, and everything in order of presentation, because the board attorney will screw with you during your presentation in order to throw you off of your mindset in your program. Okay, that's just what they do. They do it if a parent had an attorney. All right, your second part of your question is, are there any low-cost or pro bono attorneys? Yeah, they're out there, and as part of the federal law, a school system is required to provide you a list of low-cost and pro bono attorneys. It's just that a lot of parents don't know that because they don't read their parental rights, and you're required to get your parental rights once a year, and they're in there. They're out there. I don't want to get into how my office practices, but I have a very unique business model, and I wish more attorneys replicated what we're doing, because we're able to serve far more families regardless of their income, in the manner in which we do it. But a lot of attorneys don't do that, and they do require big retainers. But it is part of your parental rights to have your fees paid or reimbursed if you're able to prevail in due process. And that's a big, big, big thing. That's a big bonus. It creates a level playing field. And a parent's rates of success when they use a special education attorney, somebody who has an expertise in this area, goes up, and it's on an equal footing with a school at that point. But like I said, the parents that understand how to present the information, they do a good job. They do a good job. The reason that there's such a big disparity, though, is that there's too many out there that are arguing emotion and not arguing the substance. And, that is going to make the big difference between who wins and who loses. All right. But that's also part of the reason I created this group, is to raise the level of knowledge for parents. And the more knowledge you have, the more you understand the difference between substance and feelings, and harm and feelings. Okay. Okay.